So the federal law which prohibits nonviolent felons from possessing firearms has once again been ruled unconstitutional after the Supreme Court's recent 8-1 decision in GVR of a case. And now the DOJ just told Congress that they do not want to challenge this decision and they're gonna let it stand. Now, really quick before we jump into this video, I just want to say that if you guys want to support the channel for free, please consider subscribing to the channel. That does help the channel to grow. And then also just drop a positive comment down below because that helps tell the algorithm that you guys appreciate this type of 2A content and to share my video and other people's videos to more individuals and spread it along in the algorithm. As I mentioned in the intro, in this video, we're going to be talking about a critical Second Amendment case involving nonviolent felons and their ability to finally own firearms. The Trump administration just sent a letter to Congress notifying them that they will not be seeking Supreme Court review of a critical case called Range versus Bondi, prior known as Range versus Garland. This Range case, which was in front of the Supreme Court, involved a challenge to federal laws which prohibit someone with a nonviolent felony or a misdemeanor equivalent from being able to own, possess, or acquire firearms. The Trump administration recently asked the Supreme Court for a 30-day extension of time to file a cert petition so that they could essentially decide what they wanted to do in this case. The last time we talked about this case, I told you that the Trump administration's deadline to file that petition had essentially passed and they did not file a cert petition. I speculated that that meant that the AG's office and the new task force had essentially decided to drop this case and not proceed forward. Well, we just got that confirmed by the Solicitor General and his letter to Congress. This, coupled with the new rule which was put in place, which is finally opening the door for restoration of gun rights at a federal level, is completely changing this landscape when it comes to the issue of restoring gun rights for individuals who have nonviolent felonies or other types of, criminal charges or convictions which are barring them from possessing firearms. Now, for those not aware, this Range case involves the issue of an individual losing his 2A rights forever, essentially under federal laws, because 26 years ago, the individual, Mr. Brian Range, was convicted of concealing some of his income when he was trying to get some food stamps. Mr. Range brought this lawsuit originally in a federal district court in Pennsylvania against the federal government seeking to strike down the federal laws and the applications against him. This case went to the en banc panel for the first time, and on review, the en banc panel in the Third Circuit held that 922G1 as applied to Mr. Range is unconstitutional. The Biden administration then sought Supreme Court reversal of that decision, but after the 8-1 decision in Rahimi, this Range case was then granted, vacated, and remanded back down to the Third Circuit en banc panel for a new decision. But on re-review, the Third Circuit en banc panel essentially ruled in the same way. In that new decision, the en banc panel stated that, "We agree with Range that despite his false statement conviction, he remains among the people protected by the Second Amendment. And because the government cannot carry its burden of showing that the principles underlying our nation's history and tradition of firearms regulation support disarming range, we will reverse and remand." They stated in that opinion that at the root, the government's claim that the felons are not among the people protected by the Second Amendment devolves authority to legislators to decide whom to exclude from the people. We reject that approach because such extreme deference gives legislators unreviewable power to manipulate the Second Amendment by choosing a label. And that deference would contravene Heller's reasoning that the enshrinement of constitutional rights necessarily takes certain policy choices off the table. In sum, we reject the government's contention that felons are not among the people protected by the Second Amendment. That decision by the Third Circuit en banc panel was issued back in December. The federal government, through Pam Bondi's office, recently got an extension in the Supreme Court, and they wanted to reconsider and essentially decide how this administration wanted to handle the issue. That deadline has now passed, and we have a letter from the Solicitor General to the members of Congress, to the Judiciary Committee, and he's identifying what they decided to do in the Range case. The letter from the Solicitor General John Sauer states that, "Dear Senator Durbin, pursuant to 28 U.S.C. 5300, I am writing to advise you that the Department of Justice has decided not to file a petition for a writ of certiorari in the above captioned case. A copy of that opinion issued by the en banc panel, the United States Court of Appeals for the Third Circuit, is enclosed. In 18 U.S.C. section 922G1, Congress prohibited a person from possessing a firearm if he has been convicted of a crime punishable by imprisonment of a term exceeding 1 year. The plaintiff in this case, Brian Range, was convicted in 1995 for food stamps fraud after he signed an application for food stamps that understated his income. Although that offense, which was classified as a misdemeanor under state law, was punishable by up to 5 years of imprisonment, Range received no jail time. Range has had a clean record since then, apart from minor traffic and parking infractions and a summary offense for fishing without a license. The en banc panel in the Third Circuit held that Section 922G1 violates the Second Amendment as applied to Range. The court described its decision as narrow, emphasizing that Range's misdemeanor conviction for food stamp fraud was decades old, that Range had filed a civil suit in which he sought protection for future possession of a firearm, and that the record contains no evidence that Range poses a physical danger to others. The Department of Justice has concluded that a petition for a writ of certiorari is not warranted in this case. The Third Circuit's decision is narrow, leaving Section 922G1 untouched, except in the most unusual applications. The Supreme Court has previously declined to grant plenary review when faced with these similar decisions holding 922G1 unconstitutional, as applied to a narrow set of circumstances, including at a previous stage of this case. In addition, the Department of Justice has recently revitalized an administrative process through which an individual may obtain relief from the federal firearms disabilities if he shows that the circumstances regarding the disability and the applicant's record and reputation are such that the applicant will not be likely to act in a manner dangerous to public safety, and that the granting of relief would not be contrary to the public's interest. Because the courts of appeals have not yet had the opportunity to consider the effect of that action on the constitutional analysis, and because Range himself would likely qualify for relief under the revitalized process, the department has concluded that the Supreme Court's intervention is not warranted at this time. So this is a very interesting turn of events. There are some positives and some negatives with this letter that was sent to Congress. When looking at the letter, it appears that the administration is signaling that only unusual cases will qualify, potentially not just under this precedent in the Third Circuit, but also for the restoration application that they opened up. This means that maybe only unusual situation like Range's food stamp issue or the Cantor case, which was in the Seventh Circuit, which I believe dealt with selling counterfeit insoles over the mail and qualified as mail fraud, I guess, that maybe only those kind of weird, unusual cases would qualify for the restoration of rights. This may also mean that the new rule will only operate to help those kind of outlier individuals. It also kind of let the Supreme Court off the hook of having to address this issue once again, but that could be a positive in your mind. Maybe you think that that's good because maybe you don't want them to get bogged down with having to address this 2A issue when there's already new avenues opened up for the restoration of rights, and maybe you want them to address a different type of 2A case because the Supreme Court will only take on a certain amount of 2A cases, and they, an issue like this would qualify obviously as a 2A case, and maybe they would then be able to avoid other big 2A cases like rifle bans and magazine bans, which selfishly, I would rather them hear rifle magazine bans. Obviously I would want them to address all 2A issues, but they are not simply going to take on all cases. So maybe it's better that they don't get bogged down with this issue, and maybe that opens them up to then have to take the rifle magazine bans. Regardless, this is a step in the right direction and a win for those individuals who want to restore their rights. The larger question now will be maybe how courts will handle this as-applied challenge under the Range case and under the precedent of Range. How are they going to handle that going forward? Are they only going to consider these unusual circumstances to qualify under the precedent? And then also, how is the federal restoration application actually going to operate? Is it also only going to be for these unusual cases? That is something we're going to have to see how it plays out over time, but generally, like I said, a step in the right direction. Definitely, we didn't see this happening under the prior administration, and it seems like the 2A task force is trying to be precise about what cases they want to proceed forward, what cases do they want to elevate and litigate, and what cases do they simply want to abandon and allow kind of go to the wayside and not waste their time on when you already have good precedent down below from a circuit court like the Third Circuit en banc panel, and that will now sit as precedent. So that's what happened in this critical Range case and the whole nonviolent restoration issue. As we get more information, as this plays out and develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.